Let me also thank Sridhar sir and previous sir for coming on board. I know this was a very short organization and a short span that we've done this. So thank you, sir, both of you for coming on board. I'm also privileged to have alongside me, as always, Mr. Shivdas. This is a topic that has been quite grappling. It's a very short and small topic, but it's been quite grappling over the last 1 month, one and a half months or so, because everybody seems to be talking about force majeure, and a lot of articles written about this, a lot of news reports about this. Everybody seems to be taking some kind of an opinion on force majeure. So we thought we'll address the basic and the fundamentals of force majeure first before we could actually throw open the Q&A panel. Now, just for the sake of clarity for all participants, what we have done is we have structured the session in such a way that I will take about 10-15 minutes just to give you a crisp background of what force majeure is, what the concept is, and how it works. And then thereafter, I will have Mr. Srinivasan and Mr. Sridhar given their views for about 15 minutes each. And post that, we will throw this open to all participants for Q&A. We have about 45 minutes left for Q&A after that to be moderated by Mr. Shivdas. Now, like Prithvi pointed out, if anybody has questions while we are speaking, you may post them on the chat. We'll try and pick it up and answer those questions if it comes up during our chat. But if it doesn't, we'll try and reserve it for the Q&A during the second half of the webinar today. I'd like to, can I request Prithvi or Rupa to just give me the sharing rights so that I have a small PPT that I'd like to put out. It covers the basic concepts of, thank you, Rupa. Yes, I hope this is visible to all. Now, yes, let me just put it on full screen so that everybody can view it. Yes, I hope this is visible to all. Now, everybody knows. I mean, there's a lot of articles on this, so I'm not going to repeat a lot of what has been already said. Everybody knows that this is a French and a Latin term that has been derived, and the French term is a little bit of a wider import from the Latin word, which means superior force. The Latin word vis major is actually an act of God alone. The French term superior force actually has a wider import to include any man-made terrorist attacks or anything fired, etc. Force majeure is divided into two parts in certain countries. In civil law countries, it's codified, China, France, etc. And common law countries like ours, it takes effect in the form of a contract, and the guiding principle for a contract is essentially the contract law under India, under the Contract Act 1872. Two sections that are really important for us to cover are sections 32 and 56. Just a couple of differences between common law and civil law countries, and how this has been codified in civil law countries and not so much in common law countries. Now, just a quick refresher for people. Section 32 talks about contingent contracts, and the nature of contingent contracts is that upon a happening of a certain event, the contract really kicks in. And one of the typical examples of a contingent contract is an insurance contract, where upon a happening of a certain event, your insurance payments will kick in. That's one. For frustration of contract under Section 56, the contract needs to have undergone a fundamental change, or an impossibility, or the basis for which the contract itself has to be performed undergoes a change. Therefore, you frustrate the terms of the contract, and therefore Section 56 comes in. Now, how force majeure plays a role under 32 and 56 it's a very simple concept. Now, how force majeure works under 32 is that somebody can have a force majeure clause as part of their contract, and they can say that the contract will stand suspended, say, for 30 days or 45 days, or till the time the force majeure event actually lasts or persists. But thereafter, there is a subsequent clause in at least half the contracts that we have noticed, that if this force majeure event continues for a period of 2 months or 3 months, then the contract automatically stands discharged. Now, the word discharge is quite important here, because that relegates you back to Section 32, and that's when 32 will actually kick in. 56, on the other hand, is for scenarios where there is no force majeure clause at all, and you still have a problem performing the contract, and therefore the contract becomes impossible to perform. One of the examples that I often give people that have asked me about 56 and force majeure is, for instance, if you're an event organizer and you had an event slated for say March 25th, and you had booked all of you had booked the hall, the cameraman, the crew, etc. on March 23rd. The lockdown came into effect on March 24th. Therefore, the substance of the entire contract that was supposed to happen on 25th, which is the arena itself and the people coming in, moving out, etc., all of that stands sort of terminated, in the sense people can't really come in and go out. That being said, since the fundamental of the contract has undergone a change, it will come under the concept of frustration of contract, and therefore under section 56. So that's how broadly how 32 and 56 work, and that's how force majeure works under 32 and 56. Four kinds of there are four ways in which force majeure can be treated. The first is the direct force majeure clause, and I'll explain how it's direct with the help of these terms. Most contracts, and I would assume that all companies and all lawyers would have gone through these contracts, albeit most people would not have read force majeure clauses this much in detail up until now, because it's generally a standard clause as part of every contract. But most contracts have these particular terms as part of their contracts. You'll have disaster, you'll have panic, you'll have natural calamity, you'll have act of God, and of course your general fire and earthquake and all of that. Now, the first instance where we say direct force majeure clause with relevant terms is if you happen to have the term epidemic or pandemic in it. Now, let us go back to sometime in the month of January, when WHO declared the entire aspect of coronavirus as a pandemic, and therefore if you have the term pandemic in it, automatically you will fall under the force majeure category, and whatever is part of your clause thereafter, you will follow that. The second is when you have a force majeure clause, but you don't necessarily have the term pandemic or epidemic in it. For some people, they may not even have panic or disease or similar words like that as part of their clauses. In those events, there have been certain government notifications, office memorandums, circulars, etc., that have been issued. Now, you can relegate back to these government notifications, office circulars, and memorandums, etc., which we will run through now, to say that yes, these office memorandums and circulars have claimed force majeure to be coronavirus to be a force majeure event, and therefore fall under the bracket of a natural calamity, right? So a natural calamity is something that has been recognized, and that's something that people can really look up to. So the second is force majeure without relevant terms. The third is a force majeure clause that calls for a discharge. Like I pointed out before, if it extends beyond a certain point of time, then there's an automatic discharge of the contract and therefore falls under section 32. And the last is when there's no force majeure clause and therefore relegates back to section 56. Now, what are the conditions for invoking force majeure? You have to have a supervening event that has not been foreseen by either of the parties, and there, by happening of the supervening event, it is impossible for you to perform the contract, right? That's number two. And number three, you have taken all possible steps to ensure that performance is possible, and if thereafter it is not possible, then you come back to invoke force majeure. I put something in bold at the bottom, which is commercial hardship is not a ground. This has been deliberated upon by the courts in India, especially by the Supreme Court, in a number of judgments, where say a simple mere commercial hardship, therefore if there's an increase in the price of the performance of the contract, or there's a substantial increase in the price of a contract, in the performance of a contract, that cannot be a ground to invoke force majeure or frustration. How do you invoke force majeure? You stipulate to the opposite party and you mitigate the circumstances that are there. You try and suspend the term of the contract once force majeure is invoked. Please note, force majeure is only to suspend the terms of the contract and not necessarily to discharge it, unless it continues for a certain period of time and you're not able to perform the terms of the contract, right? And you need to have evidences to ensure that you have force majeures in, you have the event in place and how you've invoked it, what is the reason for you to invoke it, etc. Like I pointed out, there have been several notifications from the government that talk about how force majeure, how the concept of the pandemic and how the coronavirus itself can be considered as a natural calamity, and therefore a force majeure clause can be invoked. we go back to WHO, where they declared it a pandemic, and that's how it starts. And thereafter, between February and up until say last month, there have been a number of ministries, number of office memorandums and circulars that have said this is force majeure, this is natural calamity, and therefore all financial obligations and penalties have to be set aside. So we look at the Ministry of Finance under the Manual of Procurement of Goods 2017, where they say due to the disruption of supply chains, it would be considered a natural calamity. We have the Ministry of New and Renewable Energy through their office memorandums for solar projects. We've looked at the RBI moratoriums on bank loans. For 3 months, there is a moratorium on payment of EMIs. This applied to credit cards as well. We also have various notifications from the Ministry of Finance that say that the landlords cannot force residents to vacate or demand rent. We will get to how force majeure operates vis-a-vis tenancy and landlord and tenancy rights and lease rights, etc., and the interaction with transfer of property maybe in the next slide or so. We have the GST, the CGST Act, which has inserted 168A, and that talks about force majeure. I'll have Mr. Shivdas address that subsequently. Various RERA authorities, including the RERA authority, have extended the time. Now, this extension of time is vis-a-vis RERA authorities and the builder. So, for instance, if the builder was to complete a project during the time of the lockdown, that has been extended to by 3 months. And if there's a renewal of a project that the builder has to undertake during this time, then that also has to be extended, or that will be extended by a period of 3 months. We've had a small sort of gap for the Ministry of Electronics and Information Technology sector for MSMEs and startups, where there's a waiver of rent. Civil aviation authorities have directed all airlines to refund full fares, including taxes, right? A Ministry of Shipping for all public-private projects, no penal consequences, etc. Now, if you look at all of these notifications, it is similar to some of the civil countries, or for instance, some other countries which have made special legislations for the purposes of force majeure and for the purposes of the pandemic, and we'll cover that now. Let me quickly run you through the affected sectors, and we have great panelists for 2 of the sectors who can talk about how it's going to affect the sectors and what those sectors specifically have to do. The first is the aviation sector. You have various contracts. The airports, the airlines have various contracts with airports. These contracts relate to parking bays for using the facilities at the airports, and therefore the monthly payment have to be made. Similarly, the airports have a contract with the Airport Authority of India for the purposes of fuel, for the purposes of other projects, etc. So those payments also are going to be stopped. Banking, we've had several cases in the last month or so because of this coronavirus and the lockdown. Bombay and Delhi High Courts have addressed the issues of invocation of letter of credits and bank guarantees and classifications of NPAs. There's also a small banking problem when it comes to the real estate segment, renewable energy technology, employment contracts. There's a huge hue and cry about employment contracts. There have been cases that have been filed before the Supreme Court because of various MHA guidelines. Independently, though, employers are looking to have a reduction of pay or to invoke a force majeure. So that's something a little bit of a worry for a lot of people. Entertainment and sports, we've seen that in the last 2 months or so, a lot of the sport events have been cancelled. Wimbledon has been cancelled. IPL has been cancelled. Because the IPL regularly falls in May, falls sometime during the month of May and June. A lot of the contracts that are entered into prior to May, in fact, television rights, franchisee payments, license fees, etc., have all been stalled. One of the arguments is that this can be used next year with the slight increase in inflation. But if you have actually made this, these are all in the form of a deposit. So these deposits, if they are made, how do you recover these deposits? The courts have gone on to rule that if you made a deposit of say 50,000 rupees for a certain event, and the event manager thereafter goes out and makes few payments, advances to cameramen, to crew, etc., and he's say incurred 10,000 rupees of expense, he is only liable to return 40,000 rupees and not the whole 50,000 rupees, right? We have government contracts, heavy machinery, etc., insurance. We've seen instances where most insurance companies have automated transactions with certain hospitals, but for those insurance company with manual transactions where you have to go and state your insurance policy, the hospitals will call up the insurance companies and ask them if this insurance actually exists and what is the nature. These imply insurance companies will have to manually sit down and look at all of these details, and therefore it becomes difficult for them to process all of these things because the paperwork is in office. Therefore, the lockdown will not allow them to get to their office. So release of funds is an issue. We have general and commercial contracts. All general commercial contracts are covered under this, including an Amazon contract. So if you look at FMCG, apparels, retail, e-commerce, all of these things are covered under general and commercial contracts. We've seen instances where if you've ordered something on Amazon prior to the lockdown, say on March 23rd, that cannot be delivered because all non-essential items cannot be delivered. Therefore, Amazon, if you go onto Amazon, if you look at your orders, there will simply be a small note on Amazon saying that, look, we won't be able to deliver it now. Either you can get an entire refund of this, or wait till the lockdown lifts and then we'll come and return it to you. So that's a perfect example of a suspension of a contract in a force majeure. Hospitality and tourism, we've seen how OYO has invoked their force majeure vis-a-vis their partner hotels because there is no incoming or ongoing traffic, so to say, in the tourism ministry and industry. They have declared force majeure. Manufacturing and construction, we have a lot of automobile companies that are going to struggle because of their contractual relations with lower down supply chains. We don't know how they're going to cope with it. Mergers and acquisitions, another one. Usually, prior to entering into a merger or an acquisition, there's obviously an agreement, a framework agreement that is entered into between two entities. There is usually a material adverse change clause. Now, we've also seen a recent RBI circular that says that any investment coming in from China or any of the neighboring countries has to come through the government route. Therefore, investments could take a hit. Most mergers are subject to such investments. If these investments don't really come in, then there is a material adverse change and therefore mergers could be stopped. Real estate. Now, this is one sector, especially lease, that most people have called us or have asked us queries, and some of it we'll ignore private for the time being. The commercial leases that come up, and all commercial leases have force majeure clauses. There are two stands of arguments, and maybe say two schools of arguments that could be taken. One school of argument is that the commercial lease is primarily a contract, and therefore, if I have a force majeure, the force majeure should take first step, and therefore I should be waived off the rent for say 2 months. So let us assume the lockdown started in on April 1st. The whole month of April and the whole month of May, and the lockdown, we assume that the lockdown will extend till the mid of May. April and May, you won't be able to pay rent. So a lot of people have asked for waiver of rents. Fortunately or unfortunately, there are Supreme Court judgments that say that lease agreements do not fall under Section 56 for frustration of contract. Everybody mute, please. Hello, can we have everybody mute? Thank you. So we've had various queries of waiver of rents, which is not quite possible because Supreme Court has categorically said that rent agreements fall under Transfer of Property Act, specifically 108. Now, for you to claim frustration under 108, the property that you're living in or the property that you're enjoying, so to say, has to either be mutilated or damaged completely because of the earthquake or the fire or something like that. So therefore, while you're enjoying the premises as part of your rent, waiver may not be possible. What is possible is suspension and maybe deferment of the rent. So at some point of time, parties will have to sit down to negotiate and figure out how they're going to pay, say, 2 months of rent that they have not paid. So they have to pay a staggered amount at a later stage, or it could be reduced from your security deposit now, and then you refurbish the amount as part of your security deposit. So these are all issues that parties will have to consider for both commercial and private leases. RERA projects, there are three types of agreements that can come into in case of RERA projects. We've seen builder versus RERA, where RERA has actually given time for builders where there is an extension of a period of 3 months, etc. There is also builder versus a buyer problem, because if the builder has completed the project prior to the lockdown and his allotment fell during the lockdown, the allotment obviously requires you to register the contract, etc., and go to the registrar's office, which is not really possible. So he can invoke the force majeure clause. Please note, there is an agreement to sell before you enter into a sale agreement. As part of the agreement to sell, there are usually force majeure clauses, and you can actually invoke those force majeure clauses and say, look, I can't do it now. Give me a month's time, let the lockdown lift, and then we'll allot it to you after that. So that's quite possible. And the last is the buyer versus builder problem. This usually relegates back to the RBI moratorium on payment of loans. Now, I, as a buyer, would have taken a loan from a bank, and it's usually a tripartite agreement where I take a loan from the bank and the bank pays to the builder. Now, if I'm not able to pay to the bank obviously will say, look, I'm not getting any payment from the buyer, therefore I won't be able to I won't be able to give you the money for you to construct the project. So these are all issues that can come under the RERA projects. Transport, shipping, and railways, we have observed how the borders are closed off for road transport. Shipping is an issue. We've seen a recent notification on shipping contracts. Railways, the stores contracts, the work contracts, all of that will take a hit. Tax issues, there's no better person than Shivdas sir to address this, so I'll leave that portion to him. It's a very large chunk, so I'll leave that portion to him. I will quickly run through some of the frequently asked questions, and a majority of your questions can relate to all of these issues. Where an agreement does not contain a specific force majeure clause, can it be invoked? Yes, under 56 you can invoke it, subject to you proving a number of things. Please note, the onus of proving it all falls on the person who invokes force majeure. Can tenant lessee avoid payments? Answer is no. You can only defer the payment. Civil construction agreements, can FM be invoked in respect to payment of laborers? Now, this is an issue that that comes under employment law. Although I may add here that a contract labor cannot refuse payment to his laborers. He has to make payment to his laborers because that amounts to minimum wages, and we have various circulars saying that minimum wages will have to be paid. However, a builder versus a contract labor, there could be an issue and a force majeure can be raised. So that's something that has to be negotiated between the builder and the contractor. Cancellation of agreement with builders, we have seen this. Obligation of employer to pay salaries. Now, this is more of a moral obligation. Employers are required to pay salaries as per the MHA order. Now, the compulsion made by the MHA to pay the salaries is questioned before the Supreme Court. But employers generally, I'm told, that are willing to pay at least 50% of the amounts, or if they have negotiated with the employers, less than 50% as well. Bank guarantees. We will look at the Delhi High Court and the Bombay High Court judgment or orders, not judgment, orders that say that you cannot invoke bank guarantee at this stage because the performance has become impossible due to the lockdown and the pandemic, right? So there are instances where courts have said, yes, you can invoke it because these fall under essential services and you have not performed it. And there are instances where they've said, listen, this is not essential service, therefore it cannot be performed. What happens when a party is insolvent? Can one be declared NPA? Not at this stage. We have a Delhi High Court judgment order that says that NPA declaration can be stalled for a later date. And we have IBC notifications that say that IRP proceedings for the time of the lockdown will stand extended. Therefore, the time period of the lockdown will not be included as part of the number of days for IRP proceedings. So quickly to run through just 4 or 5 judgments. Orders. We have a Bombay High Court order that has said that this was with relate to a debt for pledged shares, and the stock market really crashed, so the pledged shares actually took a hit. Now, the Rural Fair Price Wholesale Limited approached the court seeking restraint from the sale of shares, and it contended that the value of the shares caused by COVID-19 and the lockdown has a fall in the stock market. The Bombay High Court has granted an interim relief for any kind of sale. Another Bombay High Court for invocation of letter of credit. This specifically relates to steel, and the Bombay High Court has taken a view that steel was an essential service and there was no restriction on movement. Therefore, performance is possible, and therefore a force majeure cannot be raised. The third one, with regard to financing facilities from ICICI Bank, determination of whether the moratorium is excluded for NPA classification. It has been noted very specifically by Bombay High Court that do not do anything till the lockdown is lifted. You can always push this aside, right? Similarly, for invocation of a bank guarantee for a petroleum drilling contract, although production of petroleum was an essential service, the drilling of the wells itself was not really essential, right? So since the person involved in this is drilling wells, he really can't perform the contract, and therefore invocation of bank guarantee was stalled. We've had two scenarios that we've observed recently. One is China. Of course, it's a civil country in the sense that they have it as part of their legislation itself. And China is giving out something known as a force majeure certificate to people if they feel that they are not able to perform. So that's a very statutory recognition that has been given by China. Singapore, on the other hand, has introduced something known as the COVID Temporary Measures Act 2020, and as on April 7, 2020. And they have about 5 kinds of contracts that they've identified, and they've given specific reliefs to these 5 kinds of contracts: construction and supply, deferral of contractual obligations, hire and purchase, goods for commercial purposes, no court proceedings, etc. Commercial and industrial property leases, landlord cannot terminate lease, suspension of rental payment up to 6 months, event related, bank related, etc. So if you look at most of the notifications that the Indian government has come up with, they sort of relate to all of these kinds of contracts alone. All of these kinds of contracts, all of these kinds of reliefs they have been given. The question again comes down to point number 3 here, which is of commercial and industrial property leases. There have been notifications that say that landlords cannot terminate the lease or evict their persons, and a police FIR and etc. can be instituted against them. But there has been no such notification saying that suspension of rental payment up to 6 months is possible. That's been given only to IT companies, which are startups or MSME. So this second portion is something that the landlord and the tenant will have to actually sit down to negotiate, and we've observed from a lot of the discussions that we've had with various clients that we have, that they are looking to sit down to negotiate instead of running to court immediately, because frankly nobody has the money to go to court at this point of time. But given that, I think it is convenient because of the relationship that you have with the landlord or with the vendor that you have. It's convenient for you to just sit down and negotiate the terms of the contract and then try to figure out how this works, right? So just to give you a brief of how this actually works, let me just just to give you a brief of how this actually works. We've looked at various scenarios. I will have Mr. P.V. Srinivasan now throw some light on how he thinks force majeure has to be dealt with by the IT industry, and what should the IT industry actually do in order to ensure that nobody.
Yeah, I am audible and visible also.
Yes, sir.
Okay, fine. In the IT sector, there are certain unique features which we may have to look at. Considering the discussion we have had so far, I will try and formulate my thoughts in 3 or 4 segments. Number 1, IT sector, there is a framework agreement called the Master Service Access Agreement, and there is a work order which are issued from time to time. So numerous work orders would be there under a framework agreement. So if there is a non-performance, the non-performance is relating to a work order, while still if there's a force majeure cause, that has to be appearing in the framework agreement. That's the Master Services Agreement. So how do you relate non-performance to the main contract? it has to be work order based and not at an overall level. So there could be a performance of one work order, and there may not be a performance of another work order for possible reason that you are working in one location and which has allowed you to do certain work. The environment has not been so bad, and you have been able to formulate and do work. From another location, you have not been able to do, and therefore now it comes into whether you want to select a work order affected by one work order is affected, whether you would like to call it a force majeure event, and the other one which is performed is not affected by a force majeure event. This selection of work orders can be a problem. So you would like to take a universal view as far as the work orders are concerned, whether it should be universally force majeure or it is not universally force majeure. Now, even in the selection, I may go a little wider. There are certain difficult policy decisions here. For example, whether you would like to say that you are affected by force majeure, then again whether we can be selective with customers or we have to be universal with all the customers. Now you cannot say I am affected by force majeure when it comes to servicing one client in the US, but another client you are claiming it to be a force majeure. That means we are selective with force majeure events. That will fall apart because the inability to perform will be tested, and obviously that test will fail. So we have to formulate a policy whether we are affected by force majeure event or we are not affected. If you are affected, we follow it wholesomely for all the clients, and that will also have to be evidence whether you have been failing to perform for all the clients or you have not been failing to perform for all the clients. So the test of force majeure has to be universal and not selective. Work order wise within a client and across the clients in terms of one client versus another client. You can be selective. For example, if you are servicing a healthcare sector and that is mission critical, where every service you are rendering is going to impact the output services from the client's part of it, then obviously you are mission critical for that particular client. There may be occasions where for that client you have performed the services but not on time. That means there are delays in performances, but it's not performed on time. That itself means there's a quality deficiency. It amounts to non-performance. In those kind of situations where you have been prevented from performing on time, that can be a claim that we are affected by force majeure, and therefore we should be protected. So I would say the selection, whether the policy of a company, whether it wants to claim that it's affected by force majeure or not, this is going to be a very intelligent selection. You cannot be very, without going into the extreme facts as to whether you have performed or not failed to perform across the board, this selection cannot be made. It cannot be a convenient selection. It has to be a very thought-through selection as to whether 60% of the contracts we have done. We cannot claim that 40% contracts with other clients are failed. So the selection of force majeure is going to be it's a policy decision which each company will have to evaluate and find out whether it has worked for them. The second part is the pandemic or epidemic as an inclusion. The clause is most unlikely because we have never seen. Even terrorism was not included originally. We started including terrorism later because terrorism was a common factor in many jurisdictions, and we started including terrorism. Now, pandemic or epidemic is unlikely to be found in a contract. Though there may be some generalities which may say that beyond reasonable capabilities, all those things you may have. So the attribute of 56 section may be found in the contract. The doctrine of frustration may be found in different words, but it's unlikely that you will have a word epidemic or pandemic in the contract. So now it becomes a real mind game. Whether you want to say that pandemic is, if pandemic is not in the contract, that means either party will have to think through whether they want to invoke a force majeure clause or they don't want to invoke a force majeure clause. I would think that we will rest this question till the end of my briefing now. Possibly we'll take this as a last question as to what should be the strategy, whether we should call ourselves affected or we should call ourselves not affected. The third part is, there is a work from home policy which the government has allowed for the IT sector. How have we formulated that policy? After all, every company is required to formulate a policy, and there is a Ministry of Corporate Affairs notification that you must have a work from home policy which should be formalized and kept in place. What is the formulation we have done? Have we said that all the workers are capable of working from home and they have been technologically enabled, they have been provided the laptops, they have the necessary bandwidth to take care, the security issues have been addressed, how they have been addressed. If all those issues have been well formulated in the work from home policy, and then possibly we are not in a position to say we are affected by force majeure, because if every step has been taken to enable workers to work from home, and all those facilities have been given as an employer would do, still there's a lack of performance, then it's a management issue and it's not a force majeure issue. So the work from home policy which we all formulated and kept it as part of the record, I think we are supposed to upload it also in the Ministry of Corporate Affairs domain. That would be a very critical document to know whether that document has in a way hinted that you are affected by this lockdown or you are not affected by the lockdown. If the policy tends to say that you can all work from home, we have enabled you, we have given the laptops, we have now gotten the necessary credentials from you, we have got the security issues addressed in a fair way. If all those assurances are coming from the work from home policy, then it's unlikely that we'll be able to claim a force majeure event. FM event will be quite difficult to establish in that case. So I would say that the work from home policy which we have formulated, that will be a very good. But nevertheless, one important factor can come in the way of performance in the IT sector. All of us work in the world of called passwords. Our systems are so triggered that we don't have a universal password which is valid for all time to come. Most companies will say the password would change every 30 days or every 45 days. If the password which has expired during this lockdown time, no doubt I have got a work from home capability, no doubt I have got all the facility, but suddenly I find on the 10th day of the lockdown, my password has expired. Most companies don't allow the password to be changed work from home from the home itself. You have to go to the office, connect to the main system in the network, and then only you will be allowed to change the password. So if this limitation comes, that means I have to necessarily go to the office to change the password. If that capability itself is not there because there's a prohibition that I can't go out of my house lawfully, then possibly we are struck by an event, very small event, that's just a matter of changing the password. It has got nothing to do with the kind of discussion we are taking. But the ability that the reasonableness that I am not able to perform my task, which is the obligations of the contract, that has been hindered because I can't access the system unless I have the password in place. I can't get the new password unless I visit the office. But I am allowed not to go to the office unless there are emergency passes which are available and they have been used or not used. All those parametrics will have it. Each IT company has been given some passes. We have all been collecting those passes from the government, and we have been using those passes to access our offices from time to time. They are all in ration. It's not that they are available in plenty. You would have prioritized the use of those passes. Again, how you have used the passes, whether the passes have been, so a documentation of whether you are really prevented from changing the password or it is making believe that it is the cause for not doing the work. All those issues will come for scrutiny. So I think it's not very easy to prove. So the reasonable cause which we are bound to establish may not be available to us. Then Mr. Prashant did talk about the Indian Contract Act. Then there are different, for example, the common law countries and the civil law countries and other things. IT contracts per se are global contracts. We are all in the export sector. That means we are going to deal with different countries. Some countries where the clients are located may be common law countries, where the Indian Contract Act may resonate and the law may be equal to what we have in the Indian Contract Act. Some countries may be civil law countries. Now, we are sitting in a common law country with the Indian Contract Act. You may be dealing with a civil law country which is codified. Now, how you want to overplay this? The sense, will you now say that the common law should apply while the civil law will yield or the codified law will prevail? Who has to now say a force majeure event has occurred or not? Again, these differences are going to be immensely difficult for us to. So I would say when there is a difficulty to reconcile between two country laws, possibly the arbitration clause which is there in the contract should help. That now how we have drafted the arbitration clause and the force majeure clause, whether they are speaking to each other, they are enabling each other. I think we may have to look at whether the arbitration clause would be a sufficient cover in case there are problems with the clients. The nature of work again is a very significant aspect. We know that we have got some on-site work. We know that offshore work. On-site work will be governed by the lockdown conditions in that country. But still, is on-site wholly independent of offshore? May not be. On-site may be 60% independent, but 40% dependent on offshore work. Whether these dependencies will have to be looked at and married through, I think it will have to, Because if there's a lockdown, for example, in India, there may not be a lockdown in the UK at the relevant point in time. They would have said, let us look for community herd immunity. And for some point, there was no lockdown in the US, UK, while we had a lockdown in India. There are many countries which don't even have a lockdown. Now I think almost many countries have a lockdown. But you have a periods when there was no lockdown in the recipient country, but we have a lockdown in India. How do you find a force majeure clause in those circumstances? Will be quite difficult to apply, because that country will say, we were always working, we were ready to get the contracts executed from our side. We were, as service recipients, we would have performed the obligations if we are willing to perform your obligations. Those kind of arguments would come. The next part, which I thought is very important for us, is that it is a force majeure in IT sector. Possibly it is so in many other cases. It's a two-way problem. It is not a one-way problem, because it's a global epidemic or pandemic, as you want to call. It's not that you are only affected. It's possible that the client is affected. Assuming that you are willing to perform the contract, but the client is not willing to receive the contract's performance, what will happen? Will you say that I have been prevented? Whether the client will claim a force majeure event and say, I am prevented from delivering, therefore I should be compensated. I wanted to perform, but the client was not willing to. So it can be a two-way problem and not a one-way problem, because in IT services, it is not that the one law applies. Here you have got two sets of laws which are applying. The other country may declare it as a pandemic, what's called a FM event, and our country may not declare it as a FM event. Then you find that the other country will claim that we were not capable of receiving the services which you wanted to provide, while we will say, we have incurred all the costs, we have got the establishment, I have got a work from home policy, I have got the infrastructure done, my deliveries are in shape. Now you must accept the delivery. Your FM is not acceptable. Therefore, you must compensate me for all the costs which have incurred, which no doubt, whether or not I have delivered. And of course, either you can say it should be covered in the billing, or you must say you must at least cover me for all the costs. You have prevented me from working, and not that I was unwilling to work. These kind of issues also may emanate in the IT sector. So it is a two-way problem. I would not say it's a one-way problem. It's a two-way problem. And because it's a two-way problem, you may find a lot of cooperation with the clients, or you may find completely different scope that you would say that you are the one who is affected more and he is less affected. All those kind of arguments can take place because the costs involved are very large. We are not sitting on small costs here. This IT sector runs on an average, say a 10 billion revenue earning company will have cost up to the extra 6 to 7 billion dollars of cost over a period of time. Take it for a quarter. We are talking of large numbers here, and therefore obviously there is going to be some amount of litigation on where the force majeure events are affected more. It's at the client's end or your end who has prevented the performance of the obligations, number one. So I would say, as far as the IT sector is concerned, there are different billing models. So there is going to be some effect. For example, if you are in the T&M model, the time and material model, obviously our revenues will suffer because we are not performing. If the time is not spent, the performance is not there, the billing is going to suffer. As far as the fixed price or the milestone-based contracts are concerned, I think most clients would be eligible, will be willing to renegotiate the milestones. Whatever milestones have been set, and those milestones are affected by this lockdown, whether in India or in the foreign country, they will not look at, say, resetting the targets. So you will find that many of them will look at putting fresh milestones and then achieving it within those parameters. If there's an outcome pricing, that unless there's an output itself is cleared by the customer, it is not going to qualify. Obviously, those events are going to be deferred. So if you are in T&M pricing, certainly your revenues will suffer. If you are fixed price pricing, your revenues may not suffer. On a quarter-to-quarter basis, it may suffer, but not in totality, because you may be able to renegotiate your contracts. If it's the outcome pricing, you may find that the contracts itself may be abandoned because the outcome, what stage of outcome you are in, and if the client is not too willing to wait for the outcome to come through for a long time to come, then you may find that the contracts itself may get abandoned. Then again, these are all whether arising out of force majeure events or they are merely arising whether, suppose the client says, the outcome pricing, I do not expect you to deliver the contract for the next 1 year, therefore this needs to be terminated, and the client terminates it, will be a FM-based termination, or it's a mere contract termination which will make you entitled to compensation. Those kind of issues can emerge in the IT sector. All terms now, because of course these events are subject to renegotiation, the credit period, the prices, volume discount, performance stars, yardsticks, everything will be amount to renegotiation. The IT sector will go through a huge rejig because if you have demonstrated that you are capable of working from home, obviously there's going to be a new model which will emerge in the IT sector, which will all try to say that we will work from home, and if the model is workable really, then many of the clients will start demanding lower prices for the contracts over a period of time, because they know the cost of establishments and other things will be saved. So you may find that new contracting terms may emerge as far as the IT sector is concerned. So this needs to be very carefully handled, because we are dealing with the international community. They understand cost as much as we understand cost. The moment we say the model is working well, it also means that it will work well even in good times. So therefore, those kind of pressures will come on us, whether we want to claim that it's working well or not working well. Those kind of metrics will have to be looked at very carefully based on our own each company's facts and circumstances. The liability caps will not appear once there's a force majeure event. I would possibly think whether IT sector should claim itself to be affected by FM. I would think it should not claim. That is my strategy. I would say that you are not affected because the government has not put an embargo which prevents us from work. The government has given a work from home policy. Our main connectivity tool, which is the telecom sector, has been performing, and all of us actually have taken more webinars in the last few days than what we have taken throughout our lives. And many people who are working from home have been able to perform that task reasonably well. No doubt it will not be equal to an office environment, but it is not anything so short that it will be found fault on quality standards. So it would have met it. Then the third one is that if you claim force majeure, then automatically, as I said, it cannot be selective. We have to be at a broad level. So again, we cannot be saying we are affected here or not affected there. The downside of claiming force majeure is that once you say you are affected by force majeure, then your vendors are also affected by force majeure should be capable of being acknowledged. There may be clauses in our vendor service agreements where they have got escalation clause or about a force majeure. For example, if there are construction contracts which we have entered into with builders, and there's a force majeure clause and an escalation clause associated with the force majeure event, then by your claiming force majeure, you are allowing the construction contractor to claim escalation. So we have to be very visible as to, we cannot look at only our client's contracts. We have to look at our vendors' contracts also to see where the vulnerability is higher. If the vendor's contract is like creating more vulnerability of FM, possibly if you have handled your clients well, it will be prudent to say we are not affected as a force majeure event. No doubt we are disrupted. No doubt there's a lack of performance or inability to perform as well as we can. These are quality issues which can be sorted out in our performances. But certainly it's not a force majeure event which prevented me from work. Therefore, I would possibly think that to claim COVID-19 as a force majeure event for the IT sector may not be the most prudent one. Particularly since you would have performed part of the work or major part of the work through work from home policy. So I would look at the work from home policy, the contractual framework, work order wise divisions, client wise divisions, across client divisions, geographical reach, and I will also see whether my vendors have got a claim on me on the force vendor events and look at it. So if these metrics can be all put together into one kind of a risk matrix, you may find that to say that COVID has been a force majeure event may not be the most prudent one, according to me. Of course, each company can evaluate the strengths and weaknesses of this argument. I will possibly leave, but in the while ending, I may say there are many state government decisions, state Supreme Court decisions in the US which are coming, which have already declared the COVID-19 as a force majeure event. They have equated it equal to a natural disaster. You find a Pennsylvania decision, Supreme Court decision, which has come just a few days back, which has declared it to be a natural disaster, and therefore it has equated into a COVID-19 situation. Now, If a court declares it to be a FM event, then possibly the ingredients of Section 56 are already found in a legislative process, or it's what's called the judicial rulings, and you find that the clients may be bound with those decisions, and they may be willing to accept a force majeure event in case you have got clients in those states, because they are, as recipients, would be bound by the decisions which they are confronted with. Again, a segregation of where the decisions are imaged, whether those clients are bound by those decisions. Therefore, we should pitch for that. Again, if you pitch for Pennsylvania and not for another state, we are again catching ourselves into two difficult situations. So I would say, go by your facts. If you have been able to perform the contract as well as you would do, you have taken all the measures to do it well. Possibly FM is not what we should claim as an IT sector.
Thank you, sir.
I will leave it to Sridhar. I will leave it back to Prashant and then leave it to Sridhar.
Sure, sir. Thank you so much, sir. Just to capture 5-6 points that sir has highlighted. One is the universal force majeure versus selective force majeure. Second is what is the strategy that needs to be. Third is a very pertinent question of contract laws and the third is what is the event? Is the event that can come up? And the last is, of course, milestone changes, renegotiation of contracts, etc. So that needs to be highlighted as well. Before I pass this along to Sridhar sir, Prithvi, can you just check? There are some people who are facing some issue with audios. Maybe I think some of them are signing off and signing in. If you can just check with them or connect with them separately, it will help them check with the audio as well. We also have one question from Mr. Arun and from Mr. Sunil, which we will take it up at the time of the Q&A, because one, Mr. Arun's questions relate to leasing of a car, and we will take up any examples of that Mr. Sunil requires as well. So I'll have Mr. Sridhar now take over and give his views on how the FMCG sector has really has to deal with force majeure. Over to you, sir.
Good morning. I hope I'm audible. Hello. Yes, I hope I'm audible. Yeah. Hello.
Sir, go ahead.
So, see, actually, from a manufacturing and an FMCG perspective, force majeure. Now, you can take this from three different aspects, three different buckets. The output side, which is very, very major, which I would call my front end. My front end. For an FMCG, the front end is the lifeline, and the input side and the factories. And the last segment, I've kept it a separate segment, the problems for exporters of food products. So because these are four major issues. As far as output is concerned, I would like to take this whole thing from an FMCG perspective. If you look at India as a nation, India has a market of over 120 crores of people. Today, the intermediate trade, whatever the goods may be in the entire FMCG, or even if you go over to, let's say, consumer electronics and electricals, sustenance is based on hand-holding. So sustenance is based on hand-holding. Sustenance is not only based on mere capability to sell downstream and the strength of your brand. So now, this pandemic has brought about a total change in the relationship of what is known as a hand-holding. This is totally different from the way Mr. P.V. Srinivasan looked at it. So hand-holding is definitely going to take a completely different perspective, I must say so. Now, therefore, tomorrow, or let's say from May 30th onwards, market sustenance programs, because there is a huge controversy today that what is relaxation, what is otherwise perhaps services considered. I would like to shift to GST for just a second. The aspect of services and goods getting mingled up, and huge issues coming up in the GST implementation side, that would itself get redefined from 1st of July or 1st of June when the country opens up again. That is the first point. Now, I don't want to elaborate, because if I elaborate, I'll have to elaborate for 3 days. So much is there on market sustenance. Now, this has got so much implication because on 22nd of March, when the market closed down, there would be 3 major things. One is stocks of primaries in transit, which is a major issue. The secondaries, which were fulfilled or unfulfilled by your intermediate trade, and what were the stocks with the retailers at large. Now, in a country like India, if PV Srinivasan can discuss from Wipro to some other multinational sitting in US or Germany a force majeure, but if I were to discuss with a 20 crore partnership firm doing 20 crore of turnover of selling only iron boxes, force majeure, it will amount to stupidity, because he is as such wanting to survive. So we must know how the whole situation changes for the industry. So force majeure would have definitely, it's a contra compared to what PV Srinivasan said, I must say so. Then apart from this, the major thing with regard to the import of goods. Now, in transit and the impact on in transit, mainly on account of capital goods and expansion projects. And finally, all packaging materials which are required, because a lot of petroleum based packaging materials are coming into India, and they are coming from outside, though Reliance is there in a big way. Now, how does those unfulfilled purchase contracts, what were the committed quantities referred in the contract? Because force majeure clause in such a description with a pandemic in it is I have not seen it. I have also looked at so many contracts for my company. I have not seen the word pandemic or an epidemic inside the force majeure. Now, therefore, that with regard to international companies selling goods to India, which are imported as packing materials, is a major issue in India. Now, the next thing would be with regard to the modern trade formats on the output side. We need to focus a bit on this. Now, today, conventional selling is otherwise happening, which is called general trade selling. There is otherwise a huge pocket called modern trade selling. Now, or this is the new format selling, if for better word. Now, for example, very simple logic. You don't have to do any big force majeure understanding of contracts. No malls are allowed to open until, in my opinion, until May 30th. Even if all other small mom and pop stores will open, malls will not open. But however, the malls have got all outlets of all the big retail formats. They are working and distributing goods to the houses, to the amenities, to the smaller places and things like that. But then this is not equivalent to customers going into the large scale formats, and thousands of people you will find on a Monday to Friday in a Spencer's retail format, which is not happening now. And which will not happen. So what would be the entire output with regard to the committed quantities? What will be the output with regard to what deliverables they have promised? What we have promised them will all be subject to negotiated settlements. And one more point which I felt which was very important, Prashant, which you didn't cover. How an arbitration clause would have to be worded in case there is a force majeure. Now, how will resolution of disputes? There is always a clause on resolution of disputes between parties in the agreement. Now, how much of arbitration? Because they have to sit and discuss. Because I don't think so. I can say that I can do away with, considering the country in a manufacturing environment. This is going to really play a huge play. Now, let's move away from output side to, let's say, factories and supply chain points. With regard to factories and supply chain point, the biggest problem which has not been raised, which was raised in a few seminars yesterday, day before yesterday, in other forums, was this. Now, if the migrant labor has disappeared from the cities and gone back to the villages, many migrant labor are willing to be transported back. Then what happens to the major supply chain logistics? Because it goes without any major intelligence data that migrant labor has got a lot to do with the logistics and movement of goods. So if migrant labor is not there, how that is going to affect the supply chain point in terms of reaching goods to your customers? Because after June 1st, even let's say we open up full ban, the question of the fact that you have to rely on a force majeure for delay in deliveries will be very difficult, because people will say, no, things have started. Hey, hook or crook, please ensure the goods reaches me. So this is another major issue, migrant labor with regard to supply chain points. The next thing is with regard to the output side. I want to go back for one particular point. Now, with regard to current sustenance programs, which have been perhaps laid out by all consumers, all consumer-oriented companies, the major issues will be also with focus to the marketing support programs, advertisement programs. All would have been linked to an event. For example, the Olympics has been postponed. The Wimbledon has been postponed. I don't want to use the word cancelled. I want to use the word postponed. Postponed. The IPL is not being held. Now I can keep on reeling out. Now, who does say that with confidence that commerce and trade is not connected to these kind of events? Commerce and trade is connected to these kind of events. So if commerce and trade is connected, so automatically arbitration, the give and take with what can be done in future episodes of these programs or future events of these programs, what I can therefore not accept now will be a very important point. So therefore, force majeure has got a major role here also. Now, what will happen to concept of tie-ups? This is another major role in FMCG or in another consumer-oriented industry. Tie-ups are a big issue these days. Now, nothing sells on its own. This is the day of the consumer. Nothing sells on its mere own. There is something added to something everywhere. So there is some good thing about some product being sold because it has got few feathers on top of it. Now, the few feathers will undergo a complete change, and that will also be a subject matter of post-pandemic recovery negotiations. Now, let us go into the let us go to the export of goods. Now, with regard to foods, nobody has raised this. This issue of sanitary certificates of foods exported from one country to another country. Now, because of the pandemic, the fact that some goods are coming in which are affected, not affected, because this virus has nothing to do with goods, even if there is it's being affected, it will be a bacterial infection mostly from a common sense perspective. But nations tend to become very conservative in these kind of times. So import of goods, mainly foods, and export of goods, mainly foods, will have a huge implication with regard to this in future, as a consequence of the pandemic, and also for the goods that are still left in port uncleared and which are left in the markets to be taken off and lifted from the markets. Coming back to the long-term agreements, which is a very, very important point I thought I should focus on. With regard to the food industry, all inputs are not readily available on off-the-shelf basis, and therefore I take it for an immediate inventory. There is something known as long-range planning. There is something known as opportunity buying, which is a major point in the food industry. There is something called opportunity buying even in consumer electronics industry, where I buy things which are cheaper now, store them and balance the cost. Now, long-term buying contracts are a specialized set of contracts. To the best of my knowledge, in long-term buying contracts till date, we have not kept the impact of a pandemic. We have kept the general force majeure, but we have not kept the effect of the pandemic. So how will they view it? Because like Srinivasan said, there is a chance one country could say, let's say if one country which is exporting an ingredient is Korea, South Korea. So they will say, we have been least affected. You could have taken it from us. So, but then we were affected. No import clearances. Though the custom ports are available, ships were not available, or aircraft clearance was not available for us. So that is a major issue with regard to, I must say, long-term agreements. Long-term agreements if they are imported, or long-term agreements if they are domestically procured also. For example, sugar trade in India is a huge subject of research itself. 12 months people study researching how to buy and sell sugar. So what would be the long-term agreements and the impact of force majeure on it? Just touching upon these things. As far as these contracts are concerned, mainly long-term agreements and advertisement, sponsorships, tie-ups, arbitration clauses are going to play a huge role, or resolution of dispute clauses are going to play a huge role in the coming months to come. I don't want to take the thunder away from Mr. Shivdas with regard to all the requests on GST, but there is a huge set of requests that will come about. Last but not the least, with regard to the FMCG industry, there is something called restart up time. I don't think so. If you say you switch on the button on 1st of June, everything is okay, it's all hunky-dory, we start on 1st June. There is a minimum setup startup time. If it's a food industry, there is a compulsory food setup startup time. So now, how will the contracts in that interregnum be reviewed is also another major issue, but that is only maximum for us 1 week to 10 days time, because getting everything on board. So therefore, the 5 major things, one of the concepts of the 5 major things said by Mr. P.V. Srinivasan, work from home has nothing to do with the hard and bolts and nuts industry. Whether you work from home or you work from anywhere else, the goods would have to reach the concerned marketplace. For that, a different set of emphasis is required. And so I must say so, hand-holding and arbitration, sitting across 2 people, sitting across on respective sides of the table, seeing each other's viewpoint, accepting something and giving away something would ensure the business will move. If you are so hard-nosed, then there'll be stoppage of business. So I think giving and taking away would be the need of the hour in the next 6 months or so. Thank you.
Thank you, sir. There's a lot of issues that sir has covered, and to truncate it down would be unfair to sir's comments. Although sir has covered output, export, manufacturing, import, arbitration clauses, and the list goes on. So thank you, sir. It was very, very insightful. Can I now request take over in terms of Q&A? Mr. Arun online. You ask your questions and I will. Mr. Arun?
Are you able to hear me? Hello?
Yeah, go ahead.
Yeah. So, like I mentioned, I represent a company in the IT sector, and we provide the possibility of employees availing car lease through the company car lease program. And the question was whether there is any possibility of reaching out to the vendor or doing the lease rental for a month or deferring it, or the company being able to avail any leeway on this, considering a possibility of claiming the force majeure clause.
Thank you, sir. Can I ask the previous sir? Then
Okay, I will answer as a commercial person. I will leave the legal aspect to you. As a commercial person, the occurrence of a force majeure event has to be notified to the other contracting party as soon as possible. Here is the case that suppose you are a company and you have got 100 cars on lease. Have you notified that the moment the government issued a notification on lockdown, have you notified the insurance, the lessor, that the cars would not be capable of being used because of the lockdown, and therefore the lease has to be suspended, terminated, or the lease rentals have to be abated? Has it been part of the contract which has been read into, then these issues will have to be looked at. I would think that we would not have done, because these leases are more in the nature of finance leases than operating leases. Finance leases, the court would try to lead it like a loan mechanism rather than a rental mechanism. though they are lease-renters, certainly, if it's a loan mechanism, at best we can look for deferrals. We can establish, unless we say we are insolvent, there is no other mechanism to say that a financial obligation can be withdrawn. A financial obligation can continue. It will continue with the deferment plans and other things, which is a matter of negotiation with the lessor in this particular contract. So if it's a financial lease, I would think there is no capability of getting the waiver of lease rentals. But if it's an operating lease, the question is whether we have notified the lessor immediately as soon as we came to know that that's a force majeure event, and therefore whether the contracts can start working based on our notification, subject to the fact that the contract itself has a FM clause within it. Then we can look at it.
Thank you, sir.
You can, Prashant, you can cover the legal aspect. I have just told what is appealing to me in my mind, knowing that I have got thousands of cars on my lease. I know what's happening. But
Sure, sir. I have Mr. Shivdas as a senior advocate to cover the legal aspect. So I'm a little
okay.
As PVS said, the difference would be between calling it as an operating lease or a financial lease. Now, the financial lease, what normally happens is obligation to pay the amount dependent upon whether therefore something like a so that obligation will continue because of the fact that you have got in your possession, you are enjoying the benefit of a place, and therefore you have to necessarily pay the rent. The force majeure clause will be difficult to enforce in the nature of a financial lease. The case of an operating lease, as PVS pointed out, you have to demonstrate as to why either the vehicles were made available and you could not use it, or he could not make it available because of these restrictions that were imposed. And therefore, whether it's a question where he was prevented from performing his obligations and therefore you don't need to pay the amount in time, you can pay it sometime later. That's a limited scope of the application of force majeure, both for either the operating lease or the financial lease in a situation like what you talked about. Is that right, Arun?
Thank you, sir. Thank you. Got it.
Before I get into the answering or taking questions from others, we had two different perspectives. One from our own PVS, who gave a completely a huge, significant perspective about the IT sector. And then, of course, our emotionally charged Sridhar, who was always furious that things are not happening the way it has to happen. And therefore, you can't expect things to start with the push of a button and all that. So what I would lay as a platform for all of us to have as questions and answers is this. Now, if you really see the way the government has responded to the COVID-19, I would say in certain aspects they have been quite proactive. They have for a first time introduced in the GST Act a definition of a force majeure, and a force majeure also specifically covers a pandemic. That's the definition of a force majeure in the GST Act. Now, the advantage of having this definition is that once the government recognizes for a particular act, for a particular statute, a particular event as a force majeure, then wherever it is possible to invoke the provisions of that statute, either as a persuasive measure or as a direct use, we can always do it and then say that this is what the government has declared. Therefore, please see whether I would fit into the definition of force majeure. That's number one. The other one, which I thought would be a better way to approach these problems, which I keep doing as a reality check, is this. What is the definition of force majeure you have in your respective agreements? There are agreements, as somebody was pointing out, that cover certain situations. There are certain agreements which are quite general in nature. In fact, I was pointing out even in the last webinar, there was one Privy Council decision which I was reading, where the contract said did not elaborate what the force majeure clauses events were. It simply said usual force majeure clause. Now the courts therefore said, when you talk about the usual force majeure clause, apply a commonsensical approach and see what did they want to cover. Now, pandemic as an event may not have been covered in some contracts, but in some contracts they are indeed covered. Now, why you did not cover pandemic is because you never foresaw the occurrence of pandemic as an event. But definitely, you would have the clause of any other unforeseeable event. Therefore, if it is any other unforeseeable event, then it is possible to cover even your pandemic or COVID-19 under that clause. That's the first one. Now, assuming that you have a clause like this, then our advice to all the people who have been talking to us is, one, try to see how is it that you fit into the clause, either directly or by implication. Now, having done that, what do we do next? We try to see what are the possible steps that he ought to have been. Suppose you are a supplier of goods, you are a supplier of service, what possible steps you ought to have taken to say that you perform your part of the obligations. Did you do it or did you not do it? Did you start doing it? Were you prevented from continuing it maybe after March 24th or March 25th, or you never started it? So all these individual factors will come into play. The third is, to the extent possible, we would always advise parties to sit together and talk that this is what has happened. This has prevented because of this. Therefore, let us try to see how we solve our problems and take it forward. According to me, in a majority of the cases, the renegotiation of the contract after purposeful discussions would be a better solution rather than try to rush into a process of litigation or arbitration. Now, Sridhar was pointing out that let us have a look at how the arbitration clause is worded. Now, arbitration clauses are generally in a particular words in all the contracts, but if it is possible to invoke that arbitration clause and then see that in your situation you are not able to do it, and therefore both of you sit together and do it, that would be a better solution. Negotiations, arbitrations would be better solutions for the disputes that could arise in this, and thereafter we can always see should we sit together and decide. In fact, we had a situation maybe I think about two weeks before. We had a major automobile manufacturer coming and meeting me and telling me that this is what is the position and this is what is happening to my supplier. Then the first question I asked, did you talk to your supplier? He said he is willing to talk, therefore I have not talked to him so far. I said talk to him. Incidentally, the supplier also happened to be a person who was talking to me. Therefore, we had a situation where both the supplier and the purchaser sat together. We went into the contract, saw the contract points, see how the points can be resolved, and then they went back saying this is the best way to do it. I think that would be, in majority of the cases in India, that would be a better way to do it. But then, as PVS was pointing out, in global contracts, you can have a different ramification altogether. It depends on whether the other country is willing to go by your negotiation process, or is he sticking only to the way in which the courts apply in their country or the contracts apply. So depending on that, these negotiations have to take place. But in all these cases, according to me, by virtue of the fact that in India you have a better statutory protection in terms of the government recognizing it as a COVID-19, as a pandemic, or as under the Disaster Management Acts, etc. We should write all the various circulars which were pointed out to you. So it's always possible to get into this and see how do we resolve the disputes. So I would lay this as the basic platform based on which we should really go into having a look at all these disputes. Yes, please. Now you can ask questions. Whoever wants to ask questions.
We don't have questions on the chat so far. I think Daya sir has asked a question. Daya sir, are you online? Hello? All right, for the benefit of everybody, I think his question is whenever they're unable to clear the goods from customs, whether demurrages can be charged by the customs and also demand rent for containers by the shipping companies.
Now, there are two things in this. One is, as far as the customs is concerned, I should be frank in telling that they have been quite proactive in ensuring that the clearances take place much faster. Now they have given very clear instructions that the customs have to work 24/7 and clear the goods as early as possible. The different circulars have been issued from time to time saying that this is how it has to be done. Now, whether the demurrage can be waived or is it necessary to be paid, that is essentially a question of discretion by the executive. According to me, the government can take a call saying that because of the fact that these are the impossible circumstances, therefore demurrage for the period from this particular period to this particular period need not be collected or can be waived. That is possible. Now, as far as the payments to the shipping companies are concerned, because they were not able to ship the goods and therefore they are unable to move in, that would be outside the ambit of a government's interference. But if it is a private contract between me and the shipping company, we can always cite what has happened in the customs, what prevented either shipping company to lift the goods or shipping company to deliver the goods or for me to take the goods. All this can be cited as instances by which we can talk to the shipping companies, either renegotiate it to say that yes, this can be waived or it can be reduced. All this can be done in terms of contracts with the shipping companies. But otherwise, as far as the government is concerned, the demurrages can be waived by them. Suitable representations can be given to the government on this.
Are there any other questions? Any other questions by anybody else?
There is one, the case of a company.
No, that we've answered. We've answered Mr. Dharan's question. To those who have requested for the presentation to be made available, yes, we will share the presentation. That's not a problem. Any other questions? Okay, concluding remarks.
So now that I think people have not raised questions either because it has been answered by both the speakers or they thought that we will have that as the platform in order to resolve their disputes. This has been an excellent webinar according to me on force majeure. It's an issue that every company really is looking at how to solve the disputes. In fact, one thing which I can definitely say that most of the companies are not looking at raising it as a dispute and go into a litigation. And as Prashant was pointing out, nobody has now the time to go in for a dispute. Nobody has the money to go in for a dispute. And also the time that would be taken to resolve the dispute would be quite long, maybe after 3 years, 4 years. And after maybe in 2022, people will now be asking what is COVID-19, what happened, how did it occur and all that. The better would be for companies to sit across and then decide this. I think it has been a great presentation by, of course, our usual PVS sir, no doubt about it. And then Sridhar. Sridhar, only one request, you should tone down your voice. I don't think you heard it.
No,
Sridhar,
now he is hearing. Huh.
you heard it. Thank you, sir. Thank you all so much.
Thanks a lot. Okay.
BCIC for their final comments, please.
Meeting ends.
Yeah. Thank you for all the panelists, PVS sir, Sridhar sir, and Shivda sir, for this wonderful panelist discussion we had, and also to Mr. Prashant for his wonderful PPT he has done, and he's kind enough to share this PPT to all our members. And we are on dot time, sir, to conclude this at 12:30.
That's right.
Yeah. So thank you all for the participants for joining the session. So we look forward for another webinar due the course.
Thank you.
Thank you all. Thank you.
Thank you, sir.